I'm here to talk a little bit about religious arbitration, but I want to start with the story. How did I get interested in religious arbitration? When I was a second-year law student and also a rabbinical school student, so I needed an internship for rabbinical school. So it happened to be, I was at Yale's law school, and the head of the Beth Din of America also was a Yale Law School grad. And so we met up, and he's like, you should come in twice a week instead of going to class. Please don't tell my students. And instead of going to class, you should come work as a clerk at the Beth Din of America. And so it was. I went to school 2 days a week. I worked for him 2 days a week. And during that time period, I had a professor, and he assigned a paper. I had to write this big research paper. And so I started telling him what I wanted to write about. I started telling him stuff, I think it's something about Montesquieu. And you could see his eyes glaze over, you know, like the second half of a day at a seminar on, oh, you know what I'm talking about. Okay, good. And then he says, I start talking to him about where I am, what I'm doing, and he says to me, oh, tell me a little bit more of what you're doing on Tuesdays and Thursdays. And I tell him a little bit about the rabbinical court. And he says to me, words that are forever etched in my memory. He says, Michael, write me a paper about what you're doing on Tuesdays and Thursdays. And that was my first foray into the topic, and ever since then I've been working on religious arbitration. The law firm I selected out of law school turns out to have been pro bono counsel to the Beth Din of America, and it's a topic I've stuck with. And now we're going to talk a little bit about arbitration going religious. I even ended up including it in my dissertation. When I made the suggestion to my dissertation advisor, she was bored stiff. She told me it was a terrible idea. 3 years later, we sat down to lunch together, and in the intervening years, the following things had happened. You may recall, a couple years back in Ontario, there was a debate raised by Rowan Williams, then Archbishop of Canterbury, about whether or not you needed to include Sharia law, Islamic law, into the British legal system, in large part to have certain forms of, as you can see on the bottom, Sharia courts providing dispute resolution services to the Muslim British community. You also had Premier McGuinty declaring in Ontario there could be no Muslim or Sharia courts addressing family law. And subsequent to that in the United States, we've had a wave of anti-Sharia laws in the United States. And this has put religious arbitration front and center in newspapers and conversation around the United States and around the world. And so when I sat down with my dissertation advisor, 3 years after she said to me, that topic is boring, she kind of picked up her fork and she said, you know, Michael, that might not have been a bad idea. And I'm like, yes, sent them all fruit baskets, thanking them for making me relevant. And so it was. It hasn't just been, though, Islamic arbitration that's been in the news. For those of you who, anybody here read the New York Times? Anybody? Not a single person. There are 2 people in the room who read the New York Times. Or everyone is so tired they can't even raise their right arms. Okay, fine, fantastic. So, it's coming, I promise. I'll have Wall Street Journal for you. It happens to be that the New York Times... Wow, such a partisan audience. Who knew? Not Jews. New York Times over the past year has run 2 articles about religious arbitration, wondering about how they fit in with the American legal system. Just a couple of weeks ago, PBS ran a special on arbitration by faith. The thing that makes me happiest about PBS's special on arbitration by faith is, if you can see really small over here, it says Pepperdine University Law School professor and rabbi, Michael Helfand. I am not a rabbi, but I have now been ordained by PBS. I am now going to issue a psak din on whether Cookie Monster can keep the cookies away from Elmo. Okay, great. So it's been in the news, and the million-dollar question in all of these cases is, to what extent can you have religious law and religious institutions governing in a state that has its own legal system? Exactly how is that supposed to work? How are those 2 legal systems meant to work together? That's the question that we're going to talk about. Now, many of you, how many people have heard of arbitration before? Okay, good. 2 good pieces of news. 1, you all know about arbitration. 2, you're awake enough to raise your hands. So if I were trying to tell you what an arbitration agreement is, I would boil it down to this. It's a private agreement to submit a dispute for binding resolution to a neutral third party. Sound good to everybody? Any quibbles? Okay, good. Step 1. That's what an arbitration agreement does. And in the United States, ever since 1925, we've had a federal policy majorly in favor of arbitration. I would say certainly within the last 30 years. And the reason people like arbitration, why parties like arbitration, has a lot to do with streamlined procedures, faster resolutions, the expertise of arbitrators, and courts like arbitration because, well, it helps them clear their dockets. There's nothing bad about that. And there's also a sense, even from within the legal system, that it allows parties to select an adjudicative process that more clearly meets their needs. So that's kind of the, oh, sure, jump on in. Okay. That's right. Yeah, so under the Federal Arbitration Act, it wouldn't be binding arbitration. You could have a separate state law that calls it arbitration or something along those lines. In fact, under 9 U.S.C. Section 7, if you don't have that binding language, it can't be enforced as arbitration. So it's like, let's call that stuff, with all due respect, faux arbitration. Yeah, okay. But it's fine. It's great. I love it. It's just not, yeah. This is true. Okay, that's all right. Okay, good, good. So this is why people like arbitration. Now, as you may know, once you have an arbitration agreement between two parties, you have an award that once the award is confirmed by a court, it has the effect of a judgment. And you can do all the fun things with it lawyers love to do. You can levy bank accounts and garnish wages, the things that bring smiles to a lawyer's face because odds of getting paid have just gone up. Okay, good, fantastic. You can confirm an award. Here's the big one. Once you have an arbitration award on an issue, there is no relitigation of the merits. Or in the immortal words of the Eastern District of New York, you cannot use a court to obtain a second bite of the esrog. This is actually a case, a Israeli arbitration award between two esrog sellers, and they tried to relitigate it, and that's what the court said. You can't get a second bite at the esrog, no matter how much you try. There are some larger words I can use to describe the same phenomenon, but courts are not going to second guess the rulings. They can't second guess the rulings of an arbitrator. Okay, great. So that's arbitration. Yes. Oh, I'll tell you all about an esrog. So on the holiday of Tabernacles or Sukkot, love it. Thank you for the question. Tabernacles or Sukkot, which comes around in the fall every single year, 7 days in Israel, 8 days in the United States. One of the mandated biblical rules is that you're supposed to bring together 4 fruit, palm branches and a fruit. One of the fruit you're supposed to bring is an esrog, and I'm so sorry that I don't have a picture for you. A citron, love it. If you Google esrog, go to Google Images, you'll see it looks like a lemon, but it's a little bumpy, and it's a nice way to make sure that our customs have made it completely into the federal judiciary, that they didn't even bother explaining it either. Okay, good. So, what makes religious arbitration religious? A couple of things. 2 basic things. You retain religious authority as the decision maker, and in addition, religious law governs the arbitration. Those are the 2 pieces. That's what makes religious arbitration religious. And the selected arbitrators are either ad hoc panels. I want Moshe, Aaron, and anybody? Generic Jewish name? Itzik. Love it. Itzik to be my arbitrators, or you might have a standing religious arbitration service provider. I am on the executive board of the Beth Din of America, although I do not speak on behalf of the Beth Din America today, and we are a standing religious arbitration service provider. So if you want to get a sense of what this would look like concretely, that's what our agreement looks like. Don't worry, here come the words. The matters in dispute between them shall be submitted to the arbitration of the Beth Din of America, and that's right. Here are the 2 features of one of our standard post-dispute arbitration agreements. 1, the matters in dispute are submitted to religious arbitrators, the Beth Din of America. 2, the arbitrator may resolve this controversy in accordance with Jewish law. You can think of it as a forum selection clause and then a choice of law provision. Those 2 things together can make plain old arbitration religious arbitration. Yes? No, so that's excellent. I'm cheating because there's not enough words on the space on the PowerPoint slides. It also allows them to use something that we call pshara krova ledin. So they may use, it says, Jewish law or let's call it settlement in accordance with Jewish law. So it gives them discretion to not necessarily apply the rules and strictures of Jewish law, but let's call it a traditional method or a theologically infused method of compromise. And there's a long story as to what the standards are for pshara krova ledin, which I look forward to discussing here with you next year. So that's why it says may as opposed to must, meaning they're limited in their discretion to those two things. So very good catch on the word may. I'm going to get a bigger screen next time, I promise. Okay, so who goes to a rabbinical court? Well, the answer is the cases submitted really run the gamut. A lot of family law matters, a lot of commercial matters, and the types of people or institutions that use religious arbitration, especially Beth Din arbitration, houses of worship, synagogues use it quite a lot. Religious schools, Jewish day schools use it quite a lot. Other religiously affiliated institutions, and of course, religiously motivated individuals will often take their disputes to Beth Din rabbinical court arbitration. Here's the key point. Anyone can choose to use religious arbitration, and it seems like, or it appears to be, that it's on the rise. When I say it appears to be on the rise, here's my best attempt to give you a sense of that. So these are statistics of commercial cases before the Beth Din of America over a 12-year period, and hopefully you get a sense, save for the 2013 dip, that they're generally on the rise. What was around 50 back in 2002 is at about around 100 commercial cases filed every year with the Beth Din of America.
If you enter into a contract between two people, you can add a clause in the contract that in the situation that may arise over which there is a conflict, that you will agree to have it heard under religious arbitration.
That's correct. Just in the same way of the agreement I described, forum selection clause, saying that the Beth Din of America, for example, will resolve the dispute, and then Jewish law will be the relevant law or the governing law to adjudicate that dispute. If you incorporate those provisions, there are other ways, of course, to do it, but if you incorporate those provisions into an agreement, or you actually sign an agreement after the dispute itself has arisen, then you'd be submitting their dispute and would be subject to the Federal Arbitration Act and function like arbitration like we all know.
You see these kinds of arbitration agreements existing between religious organizations and non-religious organizations?
I've seen one case in my life like that, yes. And that's because, this is on video so I get to say it, I like to think the product of the Beth Din of America is so good that you don't have to be Jewish to want it. Okay, good. Yes?
Are there any topics that are not subjects that are not subject that Beth Din would not consider?
So let me say something about it when I get up to public policy. When I talk about public policy, maybe raise your hand and we'll have a brief conversation on that topic. Okay, good. Now, why use religious arbitration? So I'd say the motivation to use religious arbitration, especially Beth Din arbitration, falls into two categories. First one, people want to resolve disputes in accordance with their religious rules, principles, and values. They feel religiously obligated to resolve their disputes in this manner. Now, I say this, but I want to give you like a concrete, like a statistical manifestation of this experience. So, how many people here know the difference between a pre- and post-dispute arbitration agreement? Pre-dispute arbitration agreements, something you incorporate into like an employment contract or a consumer contract. You buy your iPhone, you click I agree. You agreed before any dispute ever has arisen between you and Apple that if there is a dispute, you're going to submit it to arbitrators. Post-dispute would be after you've started fighting with somebody, you're on the onset of litigation, you decide, you know what, let's take the dispute to arbitration. The reality is almost all arbitration is pre-dispute arbitration agreements. So there's a study done of the American Arbitration Association's business-to-business commercial disputes. Here's what it looks like. Orange is pre-dispute, yellow is post-dispute. You see 2% of post-dispute, and that makes sense. All the literature will tell you. Once you know what the dispute is, both parties take a look, and somebody has figured out that it's better for them to go to court than it is to go to arbitration. And you need to have a post-dispute arbitration agreement, two parties to sign. And invariably, one of them knows it's not a good idea. And so you rarely get post-dispute arbitration. Here are the statistics of pre- and post-dispute arbitration before the Beth Din of America. You will notice that it's flipped. Here, over a period of 6 years, 97% are post-dispute, and you're probably asking yourself, they've got lawyers, doesn't somebody know that it's worse for them to go to arbitration? And the answer is maybe, but there's something pushing them over the top, making them say, even though I know my odds of winning are lower in arbitration before a Beth Din, a rabbinical court, I'm still going to go. And this is what I say, what is the first motivation for why people go. It's the sense of religious arbitration to submit disputes in accordance with religious law before a Beth Din that drives them to do so. Let me give you one other reason. This is the reason I prefer. It's what I often call the gap-filling function of religious arbitration. So let me give you an example. 2009, there's a lovely case, I think, in Arkansas. El Farah v. Sayed. I think I have the case name right. So an imam is terminated by his mosque because they don't like his sermons. The reason I like this case, sometimes I say to myself, ooh, can we do that too? Because I'm sitting in shul sometimes, in synagogue on Saturday, and I'm like, I'd love to give that guy the hook. In any event, so they terminate him. They don't like his sermons. They just don't think they're very good. And what does the imam say? He says the same thing a rabbi would say. Anybody? First thing he says is, I like where you're going. First thing he says is, what do you mean my sermons are great? Didn't you hear them? They're fantastic. You must have been sleeping. Okay, good. So that's what he says. They say he's wrong, and he files suit for breach of contract in court. Now a court is being asked to determine whether or not the sermons are good or bad. Guess what a court is not allowed to do? Courts under the Establishment Clause are not allowed to answer religious questions. They can't decide matters of religious doctrine. They can't set standards for religious conduct. And so a court can't figure out whether or not the sermons are good or bad. Well, what does that mean for the imam? That means the court dismisses his case and he's got nowhere to go to sue, because there's no adjudicative forum that can resolve the question at issue in the case. How do you resolve disputes when you're dealing with a religious employer and a religious employee, when there's religious conduct at stake? That's the void that religious arbitration fills. When you sign an arbitration agreement, even if you're dealing with a religious dispute, the arbitrators can decide the religious dispute. They're not the government. They're not subject to the Establishment Clause. And then if the arbitrators say, you know what, A owes B $10,000, a court can confirm that. Without religious arbitration, you'd have tens of thousands of employees in the United States who have job requirements that are religious in nature, where if there were ever a case or dispute that came up in front of a court, the court would dismiss it. The only way to get justice is if they have an arbitral forum, a religious arbitration forum, where somebody else can resolve the dispute. So those are the two primary motivations for why go to religious arbitration. Now, hopefully you've already gotten a sense from what I've said that courts uniformly in the United States have held that a court can both enforce an arbitration agreement and also enforce an arbitration award. And there's no constitutional issue with it. When it comes up in terms of enforcing an agreement, courts say we're just telling them to go and submit a dispute before parties they selected in the contract. We don't have to engage in any religious analysis. We don't have to decide anything about the underlying dispute. You just go ahead and do so in accordance with the neutral terms of the agreement. And when it comes to awards, courts again have uniformly held we can enforce those because, again, we don't have to get involved in the merits of the dispute. Again, you can't get a second bite at the esrog. Perfect, right. You can't do that, and as a result, because courts don't engage in a subsequent analysis, they don't have to get involved with any Establishment Clause questions. Okay, good. Time? Let's skip this case. I'll tell you a little bit about this case. This is the case that explains why I'm not allowed in the 5 towns in New York. So there was a rabbi, Nachum Brisman, who was terminated by the Hebrew Academy of 5 towns in Rockaway. And he brought a dispute before the Beth Din of America in accordance with his agreement. The Beth Din of America resolved the dispute and reinstated him. Hebrew Academy of the Five Towns in Rockaway then brought a motion to vacate the award, to throw it out, and a trial court in New York said, you know what, we're going to throw out the award. First time in the history of the Beth Din of America that one of their awards was vacated. This was very, very bad, and so Davis Polk, where I was an associate at the time, took on representation of Nachum Brisman and had the decision reversed, and the award was once again confirmed by the court. And the court's instructions to the lower court capture what we've said already. The court's attempt to say, we think that if you correctly read the contract between the parties, it was somehow voided, such that the explicit tenure provision no longer prevails. A court can't engage in that kind of second-guessing contractual interpretation. That's for the arbitrators. That's what you contracted for. You can't then, as a court, try and take that on. And so the court ends, an award is irrational if there is no proof whatever to justify the award. Otherwise, if arbitrators interpret an agreement, courts don't get to have a second bite at the esrog. Fantastic. Okay, good. Good, fun little case. Let me give you another example of where this dynamic comes up. How many people have heard of the term aguna? Chained wife. Anybody? Okay, great. Let me tell you a little bit about it. Don't worry, I'm coming back. I've learned from my mistake on Citron, and I'm going to explain this one. Here we go. So this was a Wall Street Journal article. Who was? There you go. Okay. I wasn't looking for applause. I just know I had a dissatisfied customer. So Wall Street Journal article from a few weeks ago titled, "For Orthodox Jews, a Different Kind of Prenup." And what this story is about, and that's the website that provides the quote-unquote prenup. As many of you may know, under Jewish law, only a husband can initiate the divorce proceedings. The wife cannot initiate the divorce proceedings. And sometimes nefarious, terrible, evil husbands will use this as an opportunity to either just emotionally torture their wives or to extract some sort of settlement or payment. And the goal of this prenup is to have every Orthodox couple sign the agreement when they get married, such that if there's ever a problem where the couple is no longer residing together, the husband will be required to pay the wife $150 a day. And invariably, when being a jerk costs $150 a day, well, it's just not as exciting anymore. Okay. Now, there's a little bit of a problem. The problem is the following. So here's a little snippet of the agreement. This is not the whole agreement. I cut and pasted and made this look as nice as I could. So here's what the agreement says. $150 a day remains in force so long as the two of us remain married according to Jewish law. Well, now we have a problem, right? Let's say I walk into court. A woman walks into court and says, my husband owes me $150 a day. And he says, what do you mean? I divorced you. And she said, you didn't give me the religiously required document. And he said, what do you mean? Here's this piece of paper that says you are divorced. She says, that's not good enough. What does a court say? Same response it gave to the imam. We can't resolve that kind of question. And so the key in this document is there's not just a support obligation, but it's put in tandem with an arbitration agreement to make sure there's an adjudicative body that can resolve whether or not they're married in accordance with Jewish law still. And then that decision of the rabbinical court can then be sent to a civil court for enforcement, levy bank accounts, garnish wages, lawyer smiles. Good? Question? There are a lot of very famous questions about ketubot. Ketubot, or let's call them Jewish marriage documents, they're not as explicit that it's an arbitration provision itself. They often say that they're married in accordance with the law of Moses in Israel. Some courts have read that or interpreted that to include submitting disputes to a rabbinical court, but they're not as explicit and therefore far more uncertain in terms of enforcement. Right. Right. Yeah, so if you're explicit, that's 100% right, and they're also, along these lines, you have ketubot questions, get settlement agreements. Sometimes the parties will resolve, I agree to give you a Jewish divorce, and then the husband says, I changed my mind, and the question is, can the court enforce that? So there are like a pretty nice series of questions along the way, but more explicit is better? Yes. I feel like if you're asking a question, Mr. Lewin, that you should just take the mic and I'll just sit down. You sure?
An answer to that question.
Okay.
The conservative movement with Rabbi Lieberman, who was then at the JTS, but was Orthodox, inserted in the ksuba in the 1950s a provision which was essentially a prenup.
Right.
Did exactly that.
And
It aroused enormous opposition from the Orthodox community, and then, years later, when I was in private practice, the Orthodox community asked me to write a brief that would support the enforceability of that provision. The New York Court of Appeals, in a case called Avitzer versus Avitzer, did exactly that. It said it was constitutional to include a prenup provision of that kind, and it could be enforced, requiring the parties to go to a rabbinical panel in case there was a disagreement with regard to a divorce or a split of the marriage, essentially. So that was decided by a 4-3 vote of the New York Court of Appeals in a case called Avitzer versus Avitzer, exactly with the insertion of that language in the ksuba.
Yeah.
Subsequently, the Orthodox community drafted its own prenup, which is right up there.
right. And the added little kind of, let's call it, piece of the prenup over the Lieberman proposal is the support provision. So the million-dollar question is, in a case like that, Jewish divorce, so let's say, it requires you to go to rabbinical court. Rabbinical court says you have to give your wife a Jewish divorce. And then you take that award and you go to court and you get it confirmed. Now the question is, can the court require the husband to engage in a religious act? And courts have been pretty split on that piece of the puzzle. And the added benefit of the support obligation is there's a piece that courts can enforce. The $150 a day doesn't require any religious conduct. And what that does, it gives a little bit of added teeth to make sure that there's a way to motivate people to do the right thing. I see 4 hands, and I see the time. Interesting. Let's move left to right. Go ahead.
Okay, so would a court read a provision in a prenup that says, I agree to give against, to force that person then to go to a rabbinical court?
Stop. Is it okay if I give you a mic?
Question is, just to let me know if I've got it right, whether or I think they want it for the recorder, whether or not if you had a provision in an agreement that says, I will give my wife a Jewish divorce, whether or not that's enforceable. Courts are split on that issue. Some will say it's simply neutral principles of law. We don't need to get involved in religion. The person just has to do what he said he was going to do. Some courts have said that requiring somebody to engage in a religious act violates the First Amendment, and therefore we can't enforce that provision. And it's in that void that this little support obligation fills, because on this there's no dispute. $150 a day isn't a religious act. I mean, some people may feel like giving away money is well, in any event. The point is, that's not a religious act, and that's why any court to consider this issue has considered it enforceable over and above First Amendment objections. I see a couple of hands. What I'm going to ask is, I'm going to come to them at the end and grab as many of them as time allows. Oh, okay, or not.
I had a case that I thought was going to be a simple labor or arbitration, employment or labor arbitration case that I thought I had. Turned out that the agreement provided for a bet din, a local bet din here. And one of the provisions of the agreement, which goes to enforceability, had a non-compete clause. It was a religious institution, and it was an administrator. And he couldn't do the same job for certain competitors. And I had a concern about whether or not, if we had to go enforce the agreement, if we got an award, whether if the agreement, the provisions violated, they were excessive under
I'm coming to public policy. I'm going to talk about antitrust violations and similar stuff in
Sorry,
like 3
I didn't mean to
slides.
preempt you.
No, that was a great job. I planted you to tee me up for the next slide.
On this one,
Yes.
are there any of these agreements that provide that the wife, if she wants a divorce, and she's a wealthy woman, let's say, has to pay the husband a certain amount of money?
You can get a reciprocal agreement, yes.
But are there?
Yes. Yeah, sure. Great. That was an easy one. I'm sorry that I'm not coming. You're being very. I promise to try to come at the end. Okay, here we go. So what are the big challenges, 21st century challenges to religious arbitration in the United States? So I think they fall into three categories. One is the communal pressure question, one is the public policy question, and as per the questioner before, and the last one is procedural challenges, and this last one I think is where like the real cutting edge stuff in this area is. So let me give you some examples. Courts have pretty much held across the board that communal pressure to get someone to go to a Beth Din, to go to religious arbitration, does not constitute duress. And they say things like, any member of a religious community who as a matter of conscience feels obligated to obey the laws of his or her religious organization, that's up to them. People make a decision to follow religion and not to follow religion, and therefore a community that says, we will throw you out of our religious community if you don't submit a dispute to a rabbinical court, courts say that's not duress. That's not like putting a gun to somebody's head and asking them to sign a document. Now this has caused some consternation among many, sometimes me, because we worry that what gives real teeth, power, force to religious arbitration in the United States is that parties select it to act in accordance with their religious beliefs and practices. I have sometimes argued that, well, if duress doesn't work, there's another option. In instances where, you may remember unconscionability from first-year contracts, of course you do. If you have procedural unconscionability, what Arthur Leff famously called bargaining naughtiness, where you kind of pressure somebody to sign an agreement, and then it turns out that agreement is one-sided. If you combine those things, you have enough bad stuff in there, you could invalidate an agreement. And maybe that's a way to deal with this consent problem, where if in the context of religious arbitration, somebody is being pressured by a community to sign an agreement, and then that agreement turns out to be grossly one-sided, that might give a court good grounds to invalidate it. Of course, if there's pressure under this analysis, but the process itself of religious arbitration is purely fair, even-handed, two-sided, so to speak, then you might not be able to use unconscionability, and maybe that's the right outcome. So that's one little issue to think about. I'm not going to spend much more time on it. The second one I want to talk about, so I'm sure many of you know the grounds for vacatur, throwing out an arbitration award under the Federal Arbitration Act. I'm going to talk, as promised, about public policy. So you can invalidate an arbitration award if it violates public policy. And this is very similar to like a hitman contract, right? If two people sign a hitman contract and the hitman then does what he's supposed to do, goes to jail, comes back for payment, I don't have to pay him, or the court won't enforce that agreement. This is in pari delicto. We let the parties, the dispute lie where it is, and we don't say we're going to enforce payment to people like hitmen. In the same way, an arbitration agreement, which is a creature of contract, also cannot violate public policy. So let me give you an example. The gentleman before gave a great example. Let me give you another one. So under Jewish law, you have a doctrine known as encroaching on the border. Imagine you have a pizza store. Pretty decent pizza, but they're not very efficient. And so somebody says, I got an idea. I can put that pizza store out of business real easy. I'm going to open up a really efficient pizza store 5 feet away, okay? Now, under Jewish law, that first pizza store can say, I have an affirmative right to protect my investment in my pizza store, to prohibit that second pizza store from opening up if there's quote unquote undue competition. Not going to get into what that counts for now. Imagine if you had a dispute submitted before a Beth Din, a rabbinical court, and the rabbinical court said to that second pizza store, you can't open. And then you walked into court, and you asked the court to enforce a decision that says, we can't have competition over pizza on that block. You might imagine the court would respond by saying, I'm so sorry. In the United States, we have a Sherman Antitrust Act. We don't allow that kind of anti-competitive policy. That violates public policy. And as a result, in those circumstances, a court might say, we, for public policy reasons, cannot enforce that award, or for the same reasons you described before. In any instance where you have a clear public policy, this is a nice description from the Supreme Court, such a public policy, however, must be well-defined and dominant and is to be ascertained by reference to the laws and legal precepts, and not from general considerations of supposed public interests. You need something real, like a Sherman Antitrust Act. You can't say, that's not what we do in America. show me the statute, show me the law. And if you have a decision that violates that law, that may very well be unenforceable on the grounds of public policy. Okay, good. Oh, by the way, just throwing it in for kicks, I mentioned anti-Sharia laws at the beginning. This public policy rule is why most of this anti-Sharia crusade around the United States is complete nonsense. People say, oh my God, we're going to have a Sharia court. They're going to issue a decision where they say you have to chop off somebody's arm. Guess what you're not allowed to do in the United States? Chop off somebody's arm. You're not going to walk into court and say, I'd like to confirm an award to chop off their arm. It's just not going to happen. People who say these things they're crazy. It just doesn't even make any sense.
Will walk into court and challenge the Sharia court, and they won't. If you have a woman that's intimidated by her entire community,
Yeah.
who says she has the funds to go to court?
No. Yeah. No, that's right. First of all, this is like a massively cheap process. So it may be worth noting, the only area in this context where an anti-Sharia law has been used, there's a case Soleimani v. Soleimani. I mentioned the prenups earlier. Case in Kansas. So a woman had the equivalent of an Islamic prenup, which is a mayor agreement. And she was supposed to get paid out $677,000 if her husband divorced her. And the court said in Kansas, well, we have an anti-Sharia law. An anti-Sharia law, what it's meant to tell us is there are certain legal systems that are unequal. And we think Sharia doesn't treat women well, and as a result, the woman will not receive her $677,000 payment. And you're reading this piece of paper, and you're like, is somebody reading? Did two different people write these two paragraphs? Because that doesn't make any sense. As I'm aware, it is the only reported decision in the United States that mentions an anti-Sharia law, and probably tells us something about the way in which they're going to be used. Okay. Soleimani v. Soleimani, Soleimani v. the same thing I said again.
Are Sharia laws, may they be found in print?
I'm sorry, say that again. Oh, yeah, they've been passed by, I think, 8 states or 9 states at this point. Yeah. Oh, yeah. Yeah, sure. Great website, Gavel to Gavel. If you go on, it'll give you a list of all the enacted anti-Sharia laws.
They can't be called anti-Sharia laws because they could be struck down as unconstitutional.
They can't be called anti-Sharia laws, but if you ask the legislatures in the state, they'll tell you. It just collects. If you Google anti-Sharia law, Gavel to Gavel, foreign law, you'll find a list. Okay, let's talk about a couple. I'm going to skip child custody. If somebody wants to know about child custody, I'll tell you something later. Let's do a couple more things. Let's talk about procedural challenges to religious arbitration. So I think this is like the most fascinating piece of this entire puzzle, and that just tells you that I'm a huge nerd. Okay, here we go. So courts can't allow people to relitigate the merits of arbitration, but what they must do is protect the process of arbitration. So let me give you an example. Here, there's a case, this is a New York decision, where the parties signed an agreement that they would accept upon themselves that the rabbinical court would be allowed to decide whether or not the lawyer they brought with them was appropriate. So it didn't say you can't bring a lawyer, it said we get to eyeball your lawyer, and if we don't like him or her, they're out. And after you had a dispute resolved in accordance with the arbitration agreement, the rabbinical court issues an award. The court said, no, you have a right in New York to have counsel, and not just counsel, but your counsel of choice. And because you had that rule, even though the parties agreed, your counsel of choice is a non-waivable right. The process was flawed, and therefore the award is unenforceable. Yes?
Now, courts also limit who you can have as your counsel, but you have to be admitted to bar of the state. So does this mean that federal courts can't have a bar?
I think that's a very fair question to say that if you said, in arbitration in most states, not all states, but in most states, you have to be admitted to the bar. So it would be considered the unauthorized practice of law to be an attorney in arbitration. That's a fair question. Some states do have that kind of rule. I would be surprised to learn that a court said that violated the right in the state in order to have your counsel of choice. You may say then the court's being duplicitous. It's saying its standards work, but the rabbinical court standards don't work. I think that's an interesting argument. I think that's definitely an interesting argument. Let me give you another example of a process challenge. This is one of my personal favorites. So if you're ever drafting one of these religious arbitration clauses, don't do what these folks did. You had an arbitration provision that said that it would be submitted before a panel consisting of 3 persons of the Orthodox Jewish faith. Seems reasonable enough. Here's the problem. Parties start to dispute who can be the arbitrators. I say he's not Orthodox. Now we have a little bit of trouble. And the court says, you know what? We can't enforce that provision because we can't figure out who is Orthodox and who isn't Orthodox. Now, the court then goes on to do something very interesting. It severs the provision but still sends it to arbitration. That was probably a mistake, but the core idea is correct, that when it comes to process challenges, courts have to protect the process. But if the process is linked to religious rules, courts may not be able to enforce the agreement. This has come up again in a even more challenging context, and this case has gotten an increasing amount of buzz around the United States. One of the New York Times articles interviewed Luis Garcia. Luis Garcia used to be a member of the Church of Scientology. He and his wife are no longer. The way the Church of Scientology works is, with respect to payments and arbitration, I'm not going to give you the theology of the Church of Scientology, don't know it. The way it works is you make all these payments up front. And then if you leave, the Church of Scientology doesn't give you back your payments. It's supposed to be credits for classes you take, but if you haven't taken those classes, you may want your money back. The Church of Scientology says no dice. Well, Garcia tried to challenge it, and they let him know that he had signed an arbitration agreement. And in this arbitration agreement, one of the rules was, all arbitrators shall be Scientologists in good standing with the mother church. Now that's kind of curious. You might say to yourself, if one of the clauses in the arbitration agreement says they have to be in good standing, and deciding against the church, you would assume, puts you in bad standing, then the arbitration doesn't seem very fair. Maybe it should be deemed so unfair that it's not a neutral party, and as a result, we shouldn't even consider it arbitration. Court doesn't say that and uses the same intuition I just described to you. The First Amendment prohibits consideration of this contention since it necessarily would require an analysis and interpretation of Scientology doctrine. That would constitute a prohibited intrusion into religious doctrine. We have no idea what it means to be a Scientologist in good standing. And figuring out the answer to that question would be a religious question, so we can't decide it. We can't find an objection to this arbitration agreement. Luis called me after that decision came down, and he asked for a suggestion. And so I said, Luis, here's what you should tell your lawyer. Tell him to just name a whole bunch of people to the arbitration panel. If you feel like they're arbitrators, members of the Church of Scientology in good standing, that's great. You think they are, just name them. What's going to happen? Well, the court's not going to be able to figure that out. And what happens when the court can't figure out if particular arbitrators are or are not members in good standing, are or are not orthodox? It's just going to have to cross out the provision. And that would be a way better way for you to go forward. That happens to be where the case is up to. They have briefs now filed. Each party says, one party says, you're saying they're not in good faith. And the other party says, you're saying they're not in good faith. We'll see what happens. But again, the lesson here is courts may not have to engage the Establishment Clause problems when it comes to the merits of a dispute because you can't relitigate the merits. The real challenges are when you have procedures that invoke religion. How can courts police the process under those circumstances? Yeah. Some of them are. Some of them maybe not. Oh, it's in Florida. I'm sorry. It's in Florida. If you Google around, I'm pretty sure Luis has been good about posting them in places online. And again, his case is also mentioned in that New York Times article, so you should be able to track down some good info, or if not, email michael.helfand@pepperdine.edu, and I'll send you some fun documents. Okay, good. So that's just hopefully it's clear in terms of talking about how to avoid those problems. The answer, of course, to avoiding the having to say the word orthodox or members in good standing is by identifying a service provider. So if you say, I would like 3 arbitrators named by pick your favorite institution, then there is no need to engage questions of religious doctrine. It's just call them up and they can name the arbitrators. Yes?
Instead of declaring things non-justiciable, can they just say it's a matter of foreign law, treat it as an issue of fact, and bring some experts?
Unfortunately not. So I love your intuition. I wrote an article a long time ago called Litigating Religion, where I make a very similar suggestion. I'm like, why don't we use FRCP 44.1? That's a way better way to go about thinking about these problems. That is not what courts do. They view engaging these kinds of religious questions as prohibited by the Establishment Clause. So, and if you ever want to see citations to the article, Litigating Religion, they're always preceded by the words, but see. And then it cites the article, and then it says in parentheses, the crazy thing Michael Helfand thinks is true. Nobody agrees with me, so I'm glad to have found a fellow traveler. Any other questions I was going to say? Go ahead. Oh, gentleman in the back, you had a question before, and I have some time.
It was more of a comment.
Oh.
In Illinois, the requirement to give a get may be enforced by the court where it is a part of the marital settlement agreement, and that's Goldman versus Goldman, and that's about a 10-year-old case.
Yeah, as I said, there's a split. Illinois has been good. I'm pretty sure Delaware has been bad. I may be wrong on Delaware, but I'm pretty sure Delaware has been bad. And you just have a split of cases along the lines I described before as to whether or not you can enforce an agreement to do a religious act, whether or not that violates the First Amendment. A question in the back?
Yeah, I just had to follow up on public policy.
Sure.
Matters that you were discussing in a lot of occasions that, that an arbitration provision can be an adhesion contract, one person has to take it or leave it. In your pizza parlor example, you have 2 parties that have presumably submitted to the venue to resolve their dispute. So I'm wondering, and then if you get into the issues of like civil or criminal conduct that requires intent and or that you can consent to. I'm wondering in terms of like how the public policy sort of informs the discussion of 2 people agreeing. For example, a pizza parlor contractually agreeing to close rather than it being an antitrust violation, or someone consenting under Sharia law to receive 20 lashes versus it being an assault because similar situations to that.
Yeah, so going back to the pizza example, so as you know, you can't sign an agreement to violate the Federal Antitrust Act.
Now, wait a minute. If a shopping center builds, you know just as well as better than I do, but if a shopping center builds a place and they have a pizza thing and they say you're going to be the only pizza thing, that's enforceable. That's not an antitrust violation.
Yeah, so let me just make clear. I'm surely not passing judgment on when we cross the threshold of violating the Federal Antitrust Act. I'm simply saying if you violate the Federal Antitrust Act, we determine that you violated the Sherman Antitrust Act, the fact that you signed a contract to do so isn't going to help you. And in that way, similarly, signing an arbitration agreement where you then have an award that violates the Sherman Antitrust Act, that too wouldn't help. The fact that you signed it doesn't mean that now we can enforce it. And that's, if you think about price fixing and a variety of other things, it becomes pretty intuitive that you can't sign agreements to do those things. And it may be helpful in this context to think about or conceptualize an arbitration award along the following lines. What you've really done is says, we agree to, and then a blank, and then the arbitrator fills it in. And so just like if you filled it in with something that violated the Federal Sherman Antitrust Act, it wouldn't help. So too, if an arbitrator fills that in, it doesn't help either. Yeah. Yeah.
Going back to your pie chart about pre and post dispute,
Yeah.
I can't help but thinking the reason why the American Arbitration Association is so slanted towards pre-dispute, that transactional attorneys have figured out that the American Arbitration Association sucks, and that, litigation attorneys have figured out that RCA does sort of a better job. I
Yeah.
don't have a lot of experience with RCA, but can you just give a pitch for a minute or two on why a litigator might want to
Sure. Here it comes. Values behind Beth Din arbitration. Thank you for teeing me up for the final slide. I'll say two things about it, okay? So I want to say something at the end. This is let's call it a Jewish law infused conference. So when just thinking about kind of why I'm passionate about this subject, the reason I care and the reason I spend a lot of time working with rabbinical courts and trying to improve the product and things like that. So this is going to be the quick Jewish law version of where this all comes from. Exodus 21:1, you remember that? Good, fantastic. The verse in the Bible, the Old Testament says, "Ve'ela hamishpatim asher tasim lifnehem," and these are the ordinances you shall place before them. The standard understanding of the sentence of the verse is, you shall place them before the people of Israel and tell them what the laws are. The Talmud has taken a little bit of a different gloss, which is lifnehem velo lifnei ovdei kochavim. You shall place these disputes before them, i.e. before a rabbinical court, but not before a panel of idolaters. And the idea here is that there's some prohibition about taking disputes and not sending them to be adjudicated by Jewish authorities in accordance with Jewish law and sending them somewhere else. And the question, of course, is why? Why do we have that kind of prohibition within the Jewish tradition? And I'm going to just give you a quick Maimonides gloss on it. Here's what Maimonides had to say in trying to interpret this obligation. Any person who has a judgment adjudicated before a Gentile court, even if its laws are the same as the laws of the Jewish people, he is a wicked person. And it is as if he disgraced and blasphemed and raised his hand up against the Torah of Moses, our teacher, which is pretty strong language, if you ask me. And you ask yourself kind of what's he getting at here, and kind of you read a little further. What's driving this kind of rule and this kind of rationale is the idea that the Jewish tradition believes it has the legal tools capable of addressing even 21st century problems. And the idea that somebody would intentionally reject submitting a dispute to a rabbinical court and say, I truly believe only the civil courts have the answer to my kind of question, first, doesn't even get to how challenging civil courts are, and second of all, grossly underestimates the legal power of the Jewish tradition. And I say all this because what's amazing about the system in place now, post-1925 under the Federal Arbitration Act, you have a system that has linked up civil enforcement power with the legitimate Jewish law as interpreted by Jewish authorities. That's like not a small deal. That's an incredible opportunity to actually link up our own faith and traditions with the enforcement of the 21st century state. Now, the only way that's going to work is if we figure out how we navigate the procedural pitfalls and make sure that the process is fair and even-handed, and in turn we have the right kinds of arbitrators who are successfully trained in order to provide true Jewish justice. But that's like a really cool project, an amazing opportunity that in the 21st century in the United States, the words of 3 well-trained rabbis can actually become enforceable law. So you ask me kind of, why do I spend so much time on all this? What's the pitch for the Beth Din of America Justice? That's the pitch, an amazing long-term project about taking Jewish values and making sure they're enforceable in the 21st century. That's all I have, so I'm happy to take a couple more questions. I think we have like 2 minutes. Yes?
Do you feel that some of this anti-Sharia fever that's taking over something is in any way a danger to the Jewish courts if this goes on? Because, it seems that if they don't have the right, we might lose our right as well.
So the question on the table is anti-Sharia laws, do I think that they're a threat to the Jewish community? So the original ones, I would say, sometimes I call them anti-Sharia laws 1.0. Arizona, for example, had a foreign law rule, and when it defined foreign law, it defined it as Sharia or halacha, or karma, or a couple other things. So the 1.0 versions were explicit in coming after, they presumably would have included arbitration decisions issued by Beth Din. Of course, then you get into some very complicated questions of preemption. You have a Federal Arbitration Act and you have state law rules, and there are reasons to think maybe those laws wouldn't have been enforceable, but that's just a separate side question. 2.0 has been an attempt of the anti-Sharia movement to kind of submerge the implicit bigotry of the rules and try and make them more facially neutral. Those were a little better. They still targeted foreign law. That drove the Chamber of Commerce insane because they just broadened it because they didn't want it to just be about religion. And then Chamber of Commerce is like, if you pass that law, we can't have a French choice of law provision. We're doing business with a French company, and so you're going to just bring international business to a halt. So anti-Sharia 3.0 has been rules that say we can't enforce decisions that violate the public policy of the state. So I don't think those do damage legally because, of course, you can't have anything that violates the public policy of the state. I just walked you through all of that. They're not adding anything. Then you get to a little bit of a different question, which is, why are we spending so much time on a rule of law that doesn't do anything? And the answer to that is, it's an attempt to send certain kinds of messages. And I think those are very dangerous messages, given that the law isn't doing anything. Yeah.
For the Chabad guys who are here, which we have a number, they would be here otherwise, can you tell us, in the Hasidic community, the modern Orthodox community, what do the ketubas look like? Why don't they have what the conservative movement apparently built in, even if people who don't read Hebrew are signing stuff? Why isn't, if it's not in there, why isn't it there?
I think it's a great question, especially as Mr. Lewin kind of outlined before. So a couple of things. One, the current version of the prenup that I described earlier does something beyond the provisions that were initially put in ketubot. So like the Lieberman boilerplate would have raised the First Amendment enforcement problems that I described earlier, just in terms of in some courts have interpreted laws to say we can't require somebody pursuant to a contract to give a get. Okay, so that's why that original version doesn't work. But that just pushes the question one step further, which is why don't we just incorporate the whole thing into the ketubah? And I think the worry is that it will somehow invalidate the ketubah. Now, I want to be clear. I'm somewhat skeptical of some of those arguments. I don't think they're very good, but I do think that when it comes to religious documents that deal with things like marriage and lineage and the like, a lot of institutions take conservative approaches, lowercase c.
Expert divorce attorneys right here in the room.
Well, if they would like to chat with the rabbi, what?
You're an expert on this.
Yeah.
Do you feel that if the ketubah says we agree to submit any disputes relating to our divorce or the religious aspect to the day-to-day?
And have that provision, the $150 a day?
Yeah.
Yeah, some people would say it's not valid as a Jewish divorce document. I can talk to you about this later, but Rav Sternbach recently issued a tshuva where he went after the prenup based on some wrong assumptions about how he thought it was working, but I can say the following. In certain segments of the broader Orthodox community, there are worries that the support provision creates some Jewish law problems. I think they're all wrong and mistaken and driven by stuff that, frankly, we shouldn't be considering, but when you're dealing with things like lineage and marriage and divorce, I think there's a sense in which it's better to keep the ketubah quote unquote clean than to have so that nobody ever questions its validity, and then have a separate document that parties sign that has the impact people are looking for it to have. That wasn't analysis, that was just descriptive. I'm getting head nods. I don't, what should I do?
Anything you want to say?
Would you like to?
Any comments?
Comments, questions, criticism?
Your letter statement is consistent with what some of us have been putting into action.
Okay,
Question comes up, two separate documents.
okay, good. I like it.
Would-
Go team.
Can I ask the divorce lawyers, would you say that if a person's Orthodox and getting married, that going to marriage without a prenup that says what his thing is like a bad idea?
Yes. It's a
Um,
bad idea if you're Orthodox and if you're going to be getting an actual ketubah, and there are some people who say that it's not halakhically, the marriage itself is halakhically questionable, that you don't need the get anyhow. But I would say as a general.
Let me push you a little more.
Do you mind if I interrupt for a second? Because I have a flight that I'm going to go catch in like a couple of minutes. And I'm happy for you guys to talk in my absence because it sounds like I'm done contributing. But I'm just, if anybody has a question for me, yeah.
What are the
Yeah, so like, what are the limits of public policy? Can we allow arbitration tribunal to like impose scarlet letters or things along those lines? Let me give you the legal answer and then the realistic answer. The legal answer is public policy is very limited. You'd have to probably find some sort of constitutional provision that would violate a statute, something very serious, or like something that's been embedded, like person meant non-compete clauses and things like that. You very rarely find cases that raise public policy as grounds for vacating an award. Let me also say that you don't have any tribunals requiring scarlet letters, or at least, and trying to enforce those in a court of competent jurisdiction. I suspect, regardless of what the precedent has been in terms of how we use the public policy exception to enforcing arbitration awards, if you had a tribunal that did something like that, the award would be vacated in under 2 seconds. And I think that's probably your instinct also. There's no court that's going to say, oh yeah, that's fine. The answer is, no, that's not fine. And that violates some sort of core public policy that would likely tie to certain constitutional provisions, maybe federal constitutional provisions, and would deem unacceptable. It's just an instinct. All right, on that note, a pleasure.